Hello and welcome to this evening's program with Cindy Cohn, author of Privacy's Defender. I'm Adam Savage, editor-in-chief of Tested.com, author of Every Tool's a Hammer, and former co-host of Mythbusters. I probably taught you or your kids to set things on fire. A few reminders before we get started. This program is being recorded, so we kindly ask that you set your phone on stun. If you have any questions for our speaker, please fill them out on the question cards that are on your seats or through the chat on YouTube, and let me tell you a bit about our speaker. Cindy Cohn is Executive Director of the Electronic Frontier Foundation, a San Francisco-based civil liberties organization. From 2000 to 2015, she served as EFF's legal director as well as its general counsel. Today, she spearheads a team of more than 120 lawyers, activists, and technologists who are dedicated to ensuring that technology supports speech, privacy, and innovation. And her new book is Privacy's Defender, My 30-Year Fight Against Digital Surveillance. Welcome, Cindy.
Oh, thank you. Thank you for that kind introduction.
First of all, I really enjoyed the book.
Thank you.
It's a really lovely read. We moved to San Francisco at almost the same time. I came in the summer of 1990.
Wow. It was a good time.
It was a really good time. And so I'm amazed that this book seems to be a memoir of how your whole life was set in motion by a house party you threw.
It sure was, in the Haight.
In the Haight.
In the Haight, yeah. I had some hackers show up at a party. They knew my new roommate, and and I got sent on this whole adventure. When I was kind of on the pathway to be a corporate lawyer, I had human rights stuff, and these people were just fascinating, and they were building the future.
Amazing.
Yeah.
You start the book off in the introduction. You start off with the definition of privacy, and I'd like to start with that here. Let's get on the same page about what you mean by privacy.
Yeah, a lot of people think of privacy as like the Harry Potter kind of cloak of invisibility that you throw over your head when you're about to do something you don't want anybody to see. And it definitely is that sometimes, but I think privacy is important because it's a way for people with less power to have some protection against people who have more power. And you can kind of think about this in different sizes. And the smallest size is actually in the home. My colleague Eva Galperin works with domestic violence victims who are dealing with abusers who put spyware, malware on their devices so that they can keep control over them. And these people need privacy, literally often to save their own lives and the lives of their children and to get out of a dangerous situation. Why? Because somebody who has more power over them is using surveillance to have control over them. And then you can go up to what we're seeing now with a lot of corporate surveillance, which is a way for corporations to know more about you so that they can decide increasingly how much you pay for things, but maybe what you want to buy. I mean, they definitely do that, but also just get a profile of you so that they have more control over the transactions and your lives than you do at some point, or at least they want to have leverage over you. And then we go all the way up to governments. And the very first thing that authoritarian governments usually do is double down on surveillance. Why? Because they want to keep people powerless. They want to make sure people can't organize, talk to each other, and, quite literally, get together to vote the bums out, right? You see this all over the world, but where I think we're really living with it in the United States today, it's no surprise to me that what we're seeing with the Trump administration is increasing efforts to try to surveil us. The government is now the number one purchaser of information from data brokers, and they're using that information to target where they're doing their immigration sweeps and other kinds of things that people are increasingly seeing. So if you start to think about privacy as a way for people with less power to get protection against people with more power, I think you can see why it's embedded in our constitutional systems, why it's just fundamental to self-government that we have some privacy. And to me, that's far more important than I think a lot of people give it. People often think about privacy. I often say that if you're in a policy debate and somebody says, well, we have to weigh privacy against blah, whatever blah is going to win. That's just your sign that privacy is going down, and I think we really need to lift it back up again because I think it's fundamental to self-government.
In my experience, any discussion of privacy online will yield the comment almost immediately, what do I have to hide? I Why do I need privacy?
Yeah, and I think that is really problematic, right? I mean, again, if you're a person with ultimate power, big power, maybe you don't need privacy. But I will note that the billionaires often have more privacy than the rest of us. So there's something there. But, I think that was... that can seem like a fairly easy thing to say if you're somebody who really has power already in society. I think the kind of, as you head down to people with less and less power, you'll find less and less of that statement.
Oh, interesting.
And certainly when you having privacy, we've recently seen a mother and her daughter in Nebraska where the mother went to jail for 2 years for having a conversation over Facebook Messenger with the daughter about the right to have an abortion. I suspect a couple years before that mother would have thought she had nothing to hide, so she had nothing to fear, right? It's a moving target, and we're in times when it's moving pretty fast. So even if you think that way today, I would be a little hesitant to think that that's a safe position to take for the long run.
I just want to drive this point home a little further. Like, what do you think is the biggest thing everybody in general gets wrong about privacy?
Well, I think right now people get wrong about privacy, that it's kind of a nice to have rather than essential.
Yeah.
Or maybe even not a necessary thing for people's lives. And usually that's kind of comes from a place where, one, you're not really thinking about the privacy you already have. And two, you may be thinking that you're a little more protected in society than you are. And it's not just you. Privacy is a team sport, right? So you don't have to think about, well, okay, the cops aren't going to come and pick up me. You should think about, are we worried about anybody in your contacts list, anybody who you communicate with, anybody who you love, who's in your family? And again, increasingly these days, it's an easier argument for me to make in ways that are increasingly distressing, right? Because if you don't know anybody with a green card, and you don't know anybody who doesn't have papers, and you don't know anybody who's an immigrant or looks like they might be an immigrant, I guess, because the Supreme Court said it's okay to stop those people now. Like, the circle of people who say that that the lack of privacy would never impact them is getting smaller and smaller. And I'm not happy about this, but it does make my pitch a little easier that people should care about privacy.
Well, and again, you're describing that these days it's becoming easier to make this point because we're finding more intersections with where privacy matters. But I want to go back to the insane prescience of the founders of the EFF in 1990. Yeah. This is before almost anybody had a computer in their house, and yet these folks saw the potential dangers so early on. How did that come about?
Yeah, I mean, they were already there when I met them, but the three founders of EFF were John Perry Barlow, who had a side gig as a lyricist for the Grateful Dead.
My favorite weird career ever.
He called himself the junior varsity lyricist of the Grateful Dead. John Gilmore, who really is the heart of the privacy push at EFF, and Mitch Kapor, who founded Lotus. If you've used a modern spreadsheet, you can thank or blame Mitch, but because they all came out of that, and they got together because they were hearing about Secret Service raids on people who were doing early internet technology called bulletin boards, where people were starting to talk to each other. This is before the World Wide Web. And the Secret Service was doing, and other government agencies were doing raids on these people and pulling all of their computers out. And it became clear to the three founders of EFF that, like, law enforcement didn't understand what was going on. They were being manipulated. One of the early big raids was because AT&T claimed that a secret document had been stolen, and it turned out it was not secret at all. But they started thinking about what it was going to be like when the rest of us had access to this technology that relatively few people did, and what we were going to need to build in to this digital world in order to make it kind of stand with the users, and not turn into a police state, and maybe not turn into a shopping mall. I'm not sure how successful we were on that one. And be a place that could actually handle kind of a political space, a space where people could organize and plan and meet together. And I mean, they were really prescient. They identified a few things that were really important. One of them was the need for privacy, and a particular technology called encryption, which I'm happy to talk about a little more, that facilitates,
that's your first big case.
Facilitates privacy, and also the need for the internet to be a place of where the First Amendment applied, free speech. And those were the two of the very first biggest fights, and I was the lead person handling the privacy one.
You write extensively in the book about the first big case you covered with the EFF. Am I right? In conjunction with them was the encryption case.
I was an outside lawyer at a little law firm, and the case was called Bernstein versus Department of Justice, and we challenged the government's regulations on the export of encryption, which were having the effect of making sure that nobody on the internet could have access to, could have a private conversation, could have access to the technologies that we need for privacy and security. It turns out, kind of magically, this same technology gives us privacy and security, both of which we still need more of, but we have a lot more of than we would have if we hadn't won this fight. So I got a call from John Gilmore, who I had met at a party in my house at the Haight, and he said, we've got this guy. He's a math PhD student at UC Berkeley. He's written a computer program, and he wants to publish it on the internet, and if he does, he will go to jail as an arms dealer. And I said, well, what does it do? Does it blow things up? And he said, no, it keeps things secret. Will you take the case? And I said, yes, because I wanted him to think I was cool. And because I thought it was a fascinating question, like this idea that publishing something that was designed to help do a scientific conversation, but also was a way for people to keep things secret, that the government would put somebody in jail for that seemed outrageous to me. And so we began to put this case together. It ended up being a First Amendment case, not really a Fourth Amendment case or other privacy case, because it was about his ability to publish his ideas. But it ended up freeing up encryption technology, and that's why we have it in, whether you use Signal or whether you're just navigating to your bank and you type in the bank's address and you feel confident that you actually went to your bank rather than some place that got hijacked in between. There's a lot of encryption that happens under the hood of the internet now that helps keep us pretty secure and safe, and all sorts of other places. You lose your phone, if you have to put a passcode into your phone to open it up, that's because it's encrypted. So that if you lose your phone, you don't lose everything that your phone is connected to. That's because both Apple and Google and Android put encryption in your phone that kicks in and protects you.
And that encryption still has some of its origins in the mathematical paper you helped get published. Am I right? It was sort of the basis of PGP.
No.
Oh, okay.
Actually
I'm wrong
not.
about that.
Yeah. No. The program that we fought about was called Snuffle. And if you're a bit of a geek, I can get into what it does. It takes a hash function and turns it into an encryptor. So there's actually a technical point being made by the way this thing works, that this one thing, a hash function creator that is legal, became illegal with one page of code. So what Dan was doing, Dan Bernstein, my client, was trying to make a technical point with what he was doing. But no, there was a whole other program called Pretty Good Privacy that lots of people were using to try to help keep things protected. And the guy who wrote that, a guy named Phil Zimmerman, who was from Boulder, Colorado, was actually under a federal investigation for having created the program when we launched our case. So ultimately that case went away as the government started backing away from it. But it was really terrifying. And it was terrifying for people who were trying to develop this internet. It was terrifying to a whole sector of science, mathematicians and scientists as well. I mean, cryptography is a thing that you and I like to use, but it's also actually a pretty old kind of applied math, right? Caesar had a cipher. Jefferson
Our
had
founding
a cipher.
fathers, yes. Ciphers were intrinsic to the American Revolution.
So it's both a kind of a scientific thing, it's a historical thing. It has all of these precursors that we made sure that our judge here in the Northern District of California court knew about when we put the case forward.
The case, though, the government dragged its feet. The case took over a decade to come to fruition.
Yeah, 7 or 8 years. Yeah, it did. It did. Yeah, no, they were slow to, and in fact, they did a bunch of tricks along the way. They had it regulated under the State Department. And they moved it to the Commerce Department and like made us start all over again with a whole new set of regs at one point in time. And yeah, it was hard fought. It was hard fought. They thought they were standing up for the national security of the United States, and we kind of came in and we were standing up for the future. And there was a real thing that the judge had to weigh. I mean, judges do not look askance at the federal government when they say the national security of the United States is at risk if you rule against us. That's intimidating, and we really had to point out that that wasn't really true, given that we didn't, Americans weren't the only people who could do math. So it turns out that the Germans and the Israelis and the Japanese had really good encryption too. So keeping Americans from participating and having the benefits of encryption wasn't likely to really actually give us the kind of edge that was kind of inherent in this argument. And we brought in a lot of scientists and mathematicians and computer scientists to try to explain about the internet, this new internet that wasn't even, this again, most of this stuff was before the World Wide Web. So I was trying to talk to a judge who had never experienced any of this stuff about what the future was going to be like and why it was important for us to have this tool in it. And lo and behold, she agreed with us, which felt pretty magical at the time.
I love that there's a few photos in the book, and I'm always fascinated by a book that has chosen a few photos, but the first one doesn't appear until almost halfway through, and it is I love this photo because to an average layperson, it is a nondescript door.
Yes.
But talk to me about the day that Mark Klein walked into the Electronic Frontier Foundation.
Yeah. The door is room 641A, not very far from here on Folsom Street. I don't know which direction. Folsom Street, the AT&T building on Folsom Street. That's where Mark worked. And it is the door to the room where the mass spying on Americans was implemented after 9/11. So after 9/11, we started hearing from our friends in industry. EFF, we're a tech organization. We know a lot of people in various industries, and they would come to us and they'd say, "We can't tell you what's going on, but it's massive. And you would be really upset if you knew." And we were like, "Well, give us evidence." And they were like, we can't. It's classified, or we'll get in trouble. We can't do it, but it's really massive. And so we were trying to figure out how we could get enough evidence, because unlike some other situations, you really can't go into federal court and ask for relief based on rumors somebody told you at a bar one night. And so we were looking for evidence, and in late December of 2005, the New York Times ran a story that said Bush is spying on Americans in America. And that was the first there were other hints and small things, but that was the first big public awareness that there was some kind of spying on Americans in America happening with the NSA. And about 3 weeks later, we were in EFF's offices on Shotwell Street. And a guy knocks on the front door, and he's in a trench coat and a hat, and he has this raspy voice, he's from Long Island, I believe, and very New York accent. And he said, I can't do the accent. He said, "Do you people care about privacy?" And my boss at the time, Sherry Steele, had opened the door, and she said, "Why, yes, we do." And he said, "I work at the AT&T building down on Folsom Street in San Francisco. I'd worked. He had recently retired. And I think I hooked up the technology that lets them do what the New York Times is talking about." And he had a packet of information that he had basically walked out of his employer with when he was employed, because he thought something was weird, but he didn't know what. And he handed it to us. And he said, "I hooked up a set of splitter cables, the fiber, our communications are carried on fiber optic cables. Fiber optic is light, right? A splitter cabinet splits the light. It's a set of little technologies that split the light. And the cool thing about light is that when you split it in half, you don't get halvesies. You get a full copy of everything that's carried on the light. And so he installed a bank of splitters right outside of room 641A. And one set of the communications would go on their way to their recipient, and another set would go into this room. And he's like, why did they have me do that? Like, where AT&T is not supposed to be doing anything with people's communications except delivering them. And then after the New York Times story came out, he put two and two together and said, I think that's what I did. And he showed up at our front door with the documents. I'm not sure I would have let him in. I mean, I really appreciate that Sherry did, but a lot of people show up at EFF and are in the bit of
you get your share of crackpots.
We get our share of people who legitimately believe that there's a chip in their head or something like that. And I'm not saying the government isn't doing that, but I'm also it's also often not true. But he had the schematics, and we sent them to some friends of ours who were in the telecommunications industry, and they did double check, and they said, yeah, this is what it would look like. We can't say for sure that's what they're doing because they weren't insiders, but they said, if I were going to do this, this is what I do. And one of them, a guy named Brian Reed, who's a big telecommunications guy, said, well, this doesn't look like a wiretap. This looks like a country tap.
That's a terrifying phrase.
Mm-hmm. It's still going on. We did not succeed. We scaled it back, but we did not succeed.
I love in the book you talk about the frames of litigation that you had a choice to make whether to sue the government or to go after AT&T, and I found that the subtlety of that in terms of where you choose your battles as a fascinating aspect of how the EFF does its business.
Yeah. My colleague Kevin Bankston he's just a brilliant person, and we had him thinking hard about what we could do about the post 9/11 surveillance. And so he actually, after the New York Times story came out and before Mark Klein showed up at our door, Kevin actually showed up at my house in Noe Valley and on New Year's Eve, and he had a bottle of champagne in one hand, and he knocked on the door, and I said, hi, Kevin. And he said, I want to sue AT&T. And I said,
your T-shirt.
I said, yeah, let's sue the government. He said, I said, well, come on in. But yeah, I mean, one of the things that Kevin realized that was a key insight is that the phone companies all have statutes that say they have to just make your calls. They can do things to protect their network, but other than that, they have to place your calls and protect their networks, and that's all they can do with your calls.
Hands off the rest.
They can't do the rest. And so that's a very clear duty, unlike the Wiretap Act and the U.S. Constitution, which I think should protect you as well, but honestly have a lot more hurdles to go through. So we thought, well, this is a cleaner way to get at the problem, and we should do it. And then, lo and behold, a couple weeks later, Mark shows up at our front door and hands us the schematics. I mean, it was kind of crazy the way it all came down. And then less than 2 weeks later, we were on file with our lawsuit.
I'm curious when Mark shows up with those documents, and I mean, the EFF is like, this is your dream. Guy shows up with evidence.
Yeah.
At the same time, are you a little still surprised by how correct you were to be as cynical as you feel?
Absolutely, absolutely. And there's this moment, right, where you're like, oh my God, I had this little voice in my head that said maybe I'm crazy.
Right.
Maybe this isn't true. And then you look at it and it's true. And that happened quite a bit with Mark. It happened even more, 7 years later when Ed Snowden showed up.
Yeah.
Because we had the government saying we were a little cuckoo. We didn't know what we were talking about. They would neither confirm nor deny what was going on. But underneath that confirm or deny was these people don't know what they're talking about. They're just, crazy wild-eyed activists. And we knew we were right and we believed Mark. But we couldn't get anybody else from AT&T to come and confirm what he said. So when 7 years later, Snowden shows up with such incontrovertible evidence that what we were saying was right, that the Obama administration actually admitted it, that was the big relief, where we were like, wow, we weren't just tilting at windmills. Again, I didn't think we were, but you can't not have that little voice in your head. And having Snowden show up and say, everything they're saying is correct was really both horrible, right? You don't want to be right about this, but also really, really justifying. It really felt good.
You describe a phrase in the book that shows up repeatedly throughout your career. It is the phrase, "Let me tell you about your case, little girl."
Yes, yes.
Tell me about being underestimated.
Yeah. Well, it kind of goes with the territory when you're a civil liberties lawyer at a little organization. But I do have always felt that it was a little gendered, right?
Sure.
It just was not the experience that some of the other guys who went to law school with me, who went into public interest, would have. And it's this, it was one of the things that, one of my first bosses kind of taught me how to jujitsu this moment, because I'd get on the call with opposing counsel and they would kind of proceed to try to tell me how wrong I was about the case. But in doing so, they would end up laying out their theory of the case, right? Why they thought they would win. But of course, the flip side of that is that actually gave me a roadmap for, and I do not take credit for this. It was my first boss, Bill Bald, who was the one who was like, you should flip this around. They're telling you stuff that you otherwise would have to figure out over time in a case. They're giving you their strategy.
What a delightful frame.
It was great.
While they're condescending to you, you're just making notes.
I'm just making notes. And I started fighting back at first because I'm kind of fighty. And then after a while, I learned to just sit down and shut up and take notes. And then I had a roadmap to what they thought was important. It's interesting because I tell the story in the book in the context of the government lawyer who I had in the Bernstein case, and then I ended up having as my opposing counsel in the NSA spying cases as well, a guy named Tony Coppolino.
You guys get along.
He's a prince. In fact, we're doing a 5-part podcast series about the book.
Amazing.
And I'm talking to a bunch of people, and I got to spend an hour talking to Tony. He is now retired from the Justice Department, and we went back through like what it was like on his side.
Wow. So you get to hear some stuff you didn't know.
Huge. And one of the things he said, he's like, I'm sorry that I came off as, as condescending to you. And he's like, I kind of went back and it made me think about like how I came off. And he said, he said, I was intimidated by you. And that just blew my mind. Like,
Amazing.
You never know how, my reality is still my reality,
right.
But it is not the reality, right? And he might just be being kind because I did beat him, but I don't think so. He's a really nice person, and it's something I just think it's really important to lift up at this moment, because there was a time when, even though we fought with the Justice Department,
right.
even though they were wrong, even though I think they took positions that were somewhat outrageous, like it was they understood the idea of a loyal opposition. They understood that it was our job to come forward and try to test what they were doing. And again, I definitely am critical about some of the tactics and strategies that they do there, but there was a base level of respect for the process that is not seen as much anymore, and has deteriorated a lot. And Tony's retired now. Most of the people who are my opposing counsel now have left the Justice Department, and I think they are very sad at the loss of the kind of professionalism and respect that they presented in presenting the government's case. And I think it's it feels a little nostalgic now, because it was a knockdown, drag out fight.
Right.
Like, we did not agree. We still don't agree. Even in the podcast, we don't agree. He will say now that he thought that he was absolutely right on the law, but they were wrong in history. And that he was trying
what
to.
What an interesting.
That basically. Yeah, I mean, I see where his case does a good job in the podcast. You have to listen on it, but like that, the world needed encryption, that we were right that the world needed encryption, but that he was right that the government's position was legal, and whatever. Okay. But I don't know that you would get that from today's Justice Department in a loss,
right.
that they would say anything other than the game was rigged because they lost.
Right.
And that's a loss for the country.
I want to ask about one of the regular bits of rhetorical One of the rhetorical nightmares I see is any discussion of Section 230.
Yes.
Both sides of the political spectrum, in my opinion, are awesomely wrong about it. And I'd love you to talk about Section 230 and why it's important.
Yeah, so Section 230 is, it's the bête noire of a lot of people on the left and the right now, but it is a very simple law. It says that a platform or a host of speech isn't responsible for the speech unless they're very directly involved in it. It's their speech, that's different. But it's, lawyers call this secondary liability, right? It's it's not liability for the speaker, it's liability for the people who are helping the speech happen one way or another. Usually we're talking about platforms or Wikipedia or the Internet Archive, lots of things that you don't think about. So that's what it is. It's again, as a lawyer, we call it secondary liability, but it is that's all it is. And the argument, people who are upset at big tech have been told that the reason that big tech sucks is because they're not liable for what anybody says on the thing. Now, I want to be clear, it's just civil liability. Like, they're still criminally liable. It's only civil liability, and it doesn't count for IP claims and copyright or trademark. They have a whole other not very great system, but Section 230 is just about lawsuits, civil lawsuits, for something that a speaker says. And, from our perspective, if you think about how the internet works, nobody doesn't need other people in order to speak. Maybe, I think back in the day, John Gilmore had his own server and his own ISP sure. and maybe his own root server, right? But if you think about how the internet is, there's always, we all need other entities to be able to speak online. And if you make those entities liable every time somebody is upset at something that gets said, they're not going to host speech anymore. And we're going to be back in the day where only people, it used to be the day that, that if you wanted to speak to the world, you had to have enough money to buy a printing press. And now you'd have to have enough money to pay for damages for anybody who you let speak who says anything that somebody else doesn't like. That means there's going to be less ability for everybody to speak online. And that might be okay for some instances, but it's not going to only happen to the people you hate. It's not, yeah. Right?
It'll come
and
for
right
you
now,
too.
And right now, when you talk about 230, there's this conversation in D.C. about how opposition to reining in 230 is bipartisan. Well, it's bipartisan because the things that the Republicans think are harmful and need to go off the internet are completely different from the things that the Democrats think are harmful. But they all think there's harmful stuff that has to come off the internet. But you pass this law, Marsha Blackburn, who's one of the big senators in the promoters of in the Senate, she's talking about kids get harmed because they have access to trans information. And your T-shirt, our little matchy pink ones, exactly. But this is a trans one. The LGBTQ content, the same people who are taking books out of our libraries and getting rid of, the trans story hours, drag queen story hours, are the ones who are really psyched on the Republican side for 230 kind of like liability, because they want to make sure that Facebook and Google and Wikipedia and the archive and any other hosts can't host things that they don't want people to see. And the Democrats, of course, are worried about a whole other set of things. But you have to look a little closer at why this is bipartisan. And I really worry, because at the end of the day, one of the things I think the internet was really great for was it gave a voice to people who couldn't buy a printing press.
Right.
It gave voice to people who weren't like the 5 executives in Manhattan who decided what went on broadcast TV. And I think that it's probably more than 5, but it's certainly not the numbers of people who get to speak their mind today. And again, if you think that getting rid of 230 is only going to get rid of the speech that you don't like, you're not paying close enough attention to who else wants 230 reined in. And we've already had a couple examples of this, right? We passed this law called FOSTA SESTA that started off kind of on the left with the idea that there was sex trafficking information happening on the internet through things like Backpage which was a place where you could do adult ads and things like that. And by the time that thing got through the law, first of all, it wasn't just about sex trafficking. It was about any sexual content, including like legal sexual speech. And it didn't stop the sex trafficking problem. But there is a hole in 230 right now for anything that is about sex, prostitution, or sex trafficking. And I don't think it's made a dent in the thing that they wanted it to make a dent in. But it has meant that a lot of people who used to be able to have online apply their wares online are back on the street in my neighborhood where a lot of them are. And I think it's not safe for sex workers on the street. It's a lot safer if they're not. And so I feel like we blew a hole in Section 230 in order to do a thing. We saw the process move from something that the Democrats could support to something that was really much more about the Republican anti-sex agenda, and we didn't solve the underlying problem. So, I mean, are we going to do that again?
I'm sure on this book tour, you're getting a lot of questions to give some maybe rays of light to the future, given the current times. I'm actually curious, we don't have a constitutional amendment for privacy.
No.
It strikes me that we desperately need one. But I'm just curious what that might look like if there was one that served us well.
Well, I mean, look, I'd be happy with the statute. I actually think the Constitution properly interpreted actually has a lot of privacy protection in it. And if we actually just made the Fourth Amendment make us secure in our papers and effects and our homes in the way that I think the founders meant. And I'm not much of an originalist, but I think there's a strong originalist argument here. Then we would have a lot more privacy anyway. But a comprehensive privacy statute, which is a little easier to write than constitutional amendment too. So I'm shooting a little lower than you, but it needs to have a few things in it, right? It needs to, first of all, I mean, there's some kind of technical things, like it shouldn't preempt, like California has a decent start on a privacy law. All the ones we've seen federally would actually make it worse federally and preempt our good California law. So we can't do that. We got to go up, not down. We need a private right of action. It needs to be something that you and I can enforce our privacy rights rather than expecting the already overloaded FTC or state attorney generals to enforce for us. And then it needs to have a very strong protection for us. And now there's a couple of ways you can do this. The way that I think about a lot is about secondary uses. So the way that the privacy surveillance business model works is that information that we leak all the time, because we want our phones to ring at the right place and we want to get our emails and we want to do the things, that information is being used for secondary purposes by the ad companies, by the data brokers, by the other things. If we started from the principle that information that's gathered for one purpose can't be reused for other purposes, we'd cut the knees out of this surveillance business model pretty quickly. It would take a little while, and there might be a high bar and the other kinds of things, but I think we should start with that. Another way people think about it is through something called fiduciary duties, which is a lawyer term, but it basically, if you think about when you go to your accountant can't, you tell them the truth about, your taxes and your situation, and they can't go using it to try to place ads for you. The same with your lawyers. The law has these things called fiduciary duties. If we started thinking about the people who we entrust our data to as having duties back to us to only act in our interest, that would be another way to get at this, right? But I think those are kind of some fundamentals, like really limit what data people need to collect from us, and more importantly, limit what they can do with it to ways that are consistent with serving us rather than acting against us. And I don't think it's that hard to write. There's plenty of, there's lots of law professors who have ideas. There have been things floated. We have stuff that we like and that we don't like. The actual how to write it isn't the hard part. It's getting enough will in the politicians to actually pass something.
I love the fact that in this book you have long sections of legal cases reprinted verbatim. I haven't seen that since Lenny Bruce. It occurred to me, I mean, you say it sort of outright in the beginning, the book feels like a primer on privacy and being a citizen in a properly protected country. It feels like you are, I felt like I was getting a nice, strong education in the stuff that you have dealt with for the past 30 years. Was that intentional?
Yeah, I kind of wanted you to get to ride along on my shoulder with what it looked like and also explain it. I think there's a lot of there's sense in the law because we have a specialized language and kind of processes and stuff. And, I mean, if you're a computer person, you know this world as well, or a different version of it, right? Where you can exclude people by the language that you use by using the rarefied language. And you're actually talking about really something quite simple. But because you put it in this special language, it's hard for other people to access. And so I tried to not do that. Yeah. I tried to really explain things well. I think one of the things that I brought to the conversation in talking to the courts about what the internet was a pretty good ability to translate. And so I tried to bring that same idea to the book so that people could leave it not understanding enough about how we did it and why we did it to be able to feel like they understood the strategy and they got to ride along with me in a more real way.
Well, and then also in the same way that computers engendered this, the language, the legal language is esoteric because it's can be beautifully specific.
Yes, it's very precise.
I'm a legal nerd, so I read a lot of the decisions when they come out, and I love having to read them 3 or 4 times before I understand them.
Yeah.
But you also even cover why. It's like, I think in a normal book about the subject you cover, it would just say, and we won that case. But you repeat verbatim the arguments the judge used in your favor and talk about why their arguments were so spectacularly in your favor.
Yeah.
Like you teach the audience how to read a good decision.
I hope so. And some of it is just I'm so delighted at the language. And there are very few things in life that are as cool as seeing an idea that you write to a judge come back as the law for other people. And I tried to give that moment, right? And so some of those quotes is because it's what that feels like, is it when you read your ideas back. And especially Judge Fletcher, a couple of judges actually took our ideas and made them even shinier and prettier. But but having that language come back at you is just, in a way that's going to make the world better for a lot of people. Like there's very few highs as high as that.
I once had a court case in which the judge said something off the cuff that was so much in support of the thing that I was dealing with that I paid for a transcript just so I could go back and read it whenever I wanted to.
I know, and I have them all highlighted. Exactly. So I did kind of drag you along into those moments with me a little bit. I tried not to make it too long, but I admit that I did kind of include some of the cool language that we got.
You finished the book by saying that you want to recruit the reader.
Absolutely.
Are you ever not recruiting? And who are you looking for?
I've never not recruited. There are far fewer of us. I often tell the lawyers at the EFF, the world's largest law firm is the Department of Justice. So we are always the little guy compared to them. And especially with digital rights. I mean, we have a big and robust digital rights movement now. It's international. But when I started, it wasn't. And we have grown this thing, and it's not just me, it's tons of people who have grown this thing, but we are still so small compared to the issues we're up against. And as the internet has become more important and more vital to more people's lives, this should not be a tiny little niche thing that 100 lawyers in San Francisco do. This should be embedded in our lives. And so I'm always recruiting because we're always the little guys, but the issues are just we're just on the cusp of some of the AI questions that are coming up around surveillance and free speech and copyright too. And we need a new phalanx of people to come in and do that work as well, to set this, because we're headed into a world with AI where it may not be on our side. In fact, I would argue that most people don't think it's on our side already.
I was reminded back when primary colors came out.
Oh my gosh.
And the author was anonymous. And it took about 7 months for someone to figure out who they were. And they did it with a regression analysis of the words they used in their writing.
Yeah.
Which is something that a claw agent now could do in a few milliseconds.
Yeah, well, there was a company that was selling like let famous people edit your work, and that was how they were doing it.
Oh my gosh.
I believe was. But anyway, I think Julia Angwin has sued them. But it is the case that these new technologies are supercharging a lot of the, some of the benefits of the digital age, but a lot of the problems of the digital age. And it's making it more and more important that we grab a hold and try to build some comprehensive privacy law. Like, it's not, the technology alone is not going to be able to protect us. And certainly if we keep empowering like 5 billionaires to develop the technology, it's not going to be on our side.
Well, I mean, the other side, the folks against privacy are always arguing that we're just collecting the metadata. Talk about how meta the metadata actually is.
I mean, my one of my favorite quotes in there was from an NSA guy who was like, look, we kill people based on metadata, right? Like, the NSA, this is one of those situations where occasionally, like, I'm at a conference and there's a lot of policy people, and then there's me and the NSA guys, like, in the back, kind of just talking to each other, right? Because nobody who actually does surveillance and policing and especially national security intelligence stuff thinks that metadata isn't important.
Right.
Yet they're trying to sell the country on this. And honestly, the law supports them, right?
Yeah.
The difference between content and non-content. And the Fourth Amendment doesn't protect non-content. It only protects content. So when you asked me about the Constitution, that's a thing in the Constitution that we should fix. Or honestly, just get rid of the third-party doctrine and the non-content distinction, because I don't think they're based in the words of the Constitution at all. But like, that distinction made very little sense before the digital age, and it makes no sense at all. If you think of the idea of the Constitution to give people with less power protection against people against more power, the distinction between metadata and content, or metadata content and non-content, gives us no protection.
And just to be clear, like, with the smallest amount of metadata, AI can probably figure out exactly who you are, where you are, what you're doing, and why.
It was already the case that some of the analysis said that basically with 3 location data points about you, they could identify you. And of course, you think about it, where you sleep,
right,
where you spend all day, and then one other thing. I'm not even sure how much you need the one other thing, right? For most of us, the location where you sleep and the location where you spend all day, it wouldn't be very hard to figure out who you are. And so the one other thing seems to me to be almost superfluous. So, and that's just location data, which of course is metadata, but there's other data as well. And, the calling circle information, who talks to who and how often they talk to them, and who they, mapping the network of contacts, which is a lot of what intelligence agencies does. They don't need the content at all. There's a study that I talk about in the book that was done by some Stanford PhD students that shows what you can find out about people with just like 30 days of their phone metadata. And they could tell if people had diseases. They could tell people had drug problems. They could tell. I mean, it was fascinating what they could tell, and it was just a small slice of what like Facebook knows about you, or the data brokers that buy information from all the other places know about you. So, metadata, the distinction between metadata and content, which is, sadly what Obama said when Snowden came out with information. He said, "Oh, well, nobody's listening to your phone calls; they're just gathering metadata," as if that should make you feel better. That should not make you feel better.
Yeah. We have some questions.
Oh, good.
The first one says, not a lawyer. I've heard of companies like AT&T and Twitter voluntarily working with government to share data and metadata. What progress has been made to stop these third parties from unilaterally sharing data?
Well, sadly, on the AT&T side, as I mentioned, we sued the phone companies first. They ran to Congress and got something called retroactive immunity which wasn't a thing that existed before they did that, in order to be immune from the claims that they were rampantly violating the privacy of all their customers by handing information over to the government. So it is definitely the case now that they cooperate. I mean, whether it's voluntary or not is a little kind of how you talk about it. I mean, I think they would argue that they felt coerced, that they got, demands from the government to turn information over. The same was true for the companies that participated in the other mass surveillance program, which was called PRISM. I think it's now called Downstream, where they get orders from the government to search through their entire corpus to look for information. I think there should be more that's done. We definitely, EFF did a thing for a while called Who Has Your Back, where we were tracking all the big tech companies, including the telecommunications companies, about whether they required a warrant for information, whether they required other kinds of orders, there's D orders and kinds of subpoenas and stuff for getting metadata. And we tracked, their policies about what they did. Most of them require something from the government. The problem is the something is a pretty low barrier sometimes. And in the other set of cases, we haven't talked about again, the national security letter cases. These are subpoenas that are issued to companies to turn over metadata about you. The Office of Inspectors General did a couple of reports on these, and they found that the Justice Department was giving Post-it notes to the phone company guy who was embedded in the phone company to hand over people's information. They would do these, big requests that they would paper over later. They really were not following the letter of the law, much less the spirit of the law in this. Now, what that looks like today is hard to tell because the Trump administration dismantled most of the officers of Inspector General. So we don't have a picture over the last couple of years about the use of these NSLs. What we know was that when we started, there were hundreds of thousands of them. Now,
hundreds of thousands of letters, and these national security letters are sent to people, and they're told when they read them that you can't tell anybody about them.
Tell anybody. The folks
not even
were
your
gagged
lawyer.
Forever. Yeah, at first it was not your lawyer. We scaled that back. Now you can tell your lawyer.
Oh, good.
And it's only 3 years before they have to reevaluate them. So we've won a bit, but it's still way too big. But I think it's a good recognition that it's important to have really high standards for when the companies that we entrust our information with can give that to the government, and any hole or limit or limits we make in it, they're going to run a truck through and overuse.
A question from a YouTube viewer. Yeah, Europe has massive numbers of security cameras, but much stronger data protection laws. The federal government seems to have no desire to enact data privacy. Can that be changed?
I think it should be. Yeah, absolutely. I mean, look, California's done some steps on it. A couple other states have done some things. I think it can be changed. I will say, there's good news, bad news. Europe has very strong data privacy laws. They're consumer side only. Their governmental privacies are not great. Especially around national security stuff. So I would definitely, they're a great they're a decent model on consumer privacy. I think there's things that they could do better. I think that the difference between what they were hoping to do with the GDPR, the general data privacy regulations in the EU, and what's actually been accomplished shows that there's still more work to be done. But there's a whole other conversation to be had about government access to information.
I would assume you guys are tracking other governments' approach to privacy. Are there interesting models out there for privacy protection that have been passed by other countries?
I would say on the government side, it's still pretty bad, actually. Wow. The one thing I will say is I have a good friend who's a law professor in South Korea, and he points out to me that South Korea protects metadata. And requires full legal process in order to have access to metadata. So go South Korea.
That's awesome.
And my friend Professor Park always lords that over me whenever we get together. But I think there's still work to do all across the country. There's a patchwork. There's some places that are a little better on some things and better on the others. South Africa actually issued a really great decision about mass spying, which was interesting and cool to see. The kind of mass techniques, and some of the European decisions about American access to Europeans' communications have been pretty good as well, although they keep getting fought over. But our the privacy groups in Europe are continuing to try to hack away, not so much on their own government spying on them, but on the American government spying on them. And I'm here for it. That's great.
Amazing. This simply says, how is AI changing surveillance? It's a big question.
It is, and it was actually what we drew you in here for. AI is doubling down on a lot of the surveillance issues. What AI is doing is adding an analysis level.
An ability
on the
to
top
cut through the noise.
Yeah, to cut through the noise or cut across the noise. I'm not, in ways that make the information that is collected about us far more actionable by the people who want to use it. And so a good example of this in the government context of this is Palantir. So Palantir doesn't collect data. It doesn't run databases. What it does is it provides an interface to its customers. In this case, let's call them ICE. That lets them query different databases as if it were one, and then do analysis on top of that. So we know that there's a Palantir product called Elite that ICE is using to try to create heat maps of where people are who are targets for immigration raids. Now remember, we know that from pretty decent data that about 70 to 75% of the people who are getting swept up in these raids don't have any violent history, no criminal history at all, and many of them don't even have final orders of deportation. So this idea that they're looking for the worst of the worst or people who are criminal, that's not what's happening. But what Palantir is doing is letting them use information from HHS, Health and Human Services, Medicaid data type stuff, IRS data, and giving them a way to use all of this other data about people to create these heat maps that then they're being used for the sweeps. And why do I know this? Because an ICE agent in Oregon testified to this under oath in a court case. So that this is how they're using this tool. Now, we don't know exactly we know a bit about which databases are in there, but we don't know the full picture yet. But what is AI doing? AI is letting them go from all of this disparate data all across the different agencies into actionable decision making by the agents about where they're going to raid. And you just can't, that's both in their ability to look at multiple databases, but also to do this analysis on top of it. So AI is taking a lot of the problems with this secondary uses of data, right? Nobody gave Medicaid data or IRS data in order to make sure that ICE could locate you when they're going to deport your family. It's all secondary or even tertiary third uses of this data. So we kind of get back to this question, like we really do need to reinforce this idea that information given for one purpose can't be reused for other purposes, except in really, really high circumstances. And let me tell you, a checkbox is not that.
Every convenience carries a cost, right?
Well, it can, but it doesn't have to. I mean, I guess that's the piece. I mean, I'm very pro technology. I think AI can do some really cool things. Maybe not. I mean, I think it's being massively oversold, but like especially when you think about pharmaceuticals, when you think about people who are trying to deal with like oceans and the effect of climate change on it. Like AI can, these tools can do a lot of cool things. And we ought to fight for a world in which we get our toys and our privacy and control too. Like this idea that you have to trade those off is something people are trying to sell you.
Right.
As they're trying to sell you other things. You don't. We can have our cake and eat it too, and that's what we should push for.
It's like there's this simultaneous message coming from the other side that like it doesn't really matter, and also the genie's out of the bottle anyway, so you can't put it back in.
Yeah.
But you can put it back in.
I think we can. And I've often had people ask me, this is another question I get is, isn't it all over? Isn't privacy over? Our stuff is everywhere. And I was like, well, if that were the case, Facebook would be like, thanks guys, we're not gonna track you anymore. Right? That is not how it works. First of all, the most recent data is the most powerful data. It's the most actionable. It's even if you're talking about just placing ads or deciding what to charge you for whatever, it's your most recent data that is the most important. So it is not over just because they have some data about you. And again, the tell for that is that if it wasn't important for them to keep collecting data on you, they wouldn't spend the money to do it. But it's also just the case, again, this is the EFF NSA in the back of the room. The old data is far less valuable than the newest data, which is why the minute we cut it off, we begin the process of them not getting value out of the data anymore. So the best time to pass a privacy law is yesterday, and the second best time is tomorrow.
You have in the book, one of the pictures that you chose was a parody patch for the NSA.
Yes.
But what I find hilarious is I have seen a non-parody actual patch from the NSA that was an octopus.
Yes.
With its arms wrapped
Yes.
around the world that says "We know everything" or some version of that.
Collect it all is their
Collect it all,
strategy.
that's it.
Yeah, no, they are not. We don't have to go very far to parody them. Yeah, my EFF has an incredible art department, and they did this as a sticker, and we loved it so much that they put it on a T-shirt for me.
I need one of those T-shirts.
Yeah, we will get you one.
Okay.
And yeah, they really. I mean, this comes out of some of the Snowden revelations, but it's not a secret inside the agency that they have this theory that if they can watch everybody all the time, they can make us safer. And I think that there are people there who actually believe that.
The Panopticon is...
Yeah, that it's the safest place in the world to be. And of course it is if you're the person running the Panopticon. It might be really safer for you, but it's not safer for the people you're watching. And at the end of the day, you have to, part of the reason why we care about privacy is because we know how powerful it can be in the hands of the watchers. It's the same way we care about free speech. I don't care about free speech because I think that everything everybody says is great. I care about free speech because I don't want to give anybody the power to censor my friends.
Yeah. The EFF, here, this is a question. The EFF has grown immensely while you've been at the helm.
Yes.
Not only in size, but in impact and national recognition. How has it felt to lead an organization as it and its importance has grown rapidly? Was it scary? Any advice for future leaders?
Well, thank you for that lovely question. Yeah, it's definitely scary. The stakes are higher and they keep getting higher. And while we win a lot, I think I suffer the losses as well. Again, it's really fun to get to wake up every day and feel like you're part of the good guys and you're trying to make the world better. That is great. But it is not the case that the real victory are the friends we made along the way. Like, we got to win. Right. It's important for people's privacy in their lives. So I think that as the scope of what we're doing has gotten bigger, the responsibility has felt bigger and the organization has grown to try to meet them. But getting that balance right is really hard. We are lucky. We have a very strong and loyal membership that wants us to take on all the new challenges, and we've been able to grow. I think that one of my failings or limitations as a leader is in my head. We're still like a little merry band of 13 people in a tiny little office, when the reality is we're much bigger.
You're over 100.
120 people, yeah. And so I think that's, in some ways, that's my challenge as a leader is kind of realizing that it's a whole different skill set to run a bigger organization. It's one of the things I'm excited. I'm stepping down in about a month.
You're not leaving the organization.
I am. I'm going to leave EFF. I mean, I'm not done suing the government, but I'm going to leave EFF. I think after 26 years, it's important for the health of an organization to have new leadership and to let people, we're living in a time where there are some people of a certain generation who are not letting go of the reins of power. And I wanted to model the whole George Washington teach him how to say goodbye thing, right?
Yes.
But our new leader is Nicole Ozer, who was the person who started the ACLU local chapter on technology. She's amazing, not chapter, but section on technology. She's incredible. She's also just the right leader for an organization of our size and where we are right now in a way that I kind of backed into
Amazing.
this role. She's like leaning right into it, and I'm really excited for where the organization's going to go under Nicole's leadership. But it is scary, right? And it does feel sometimes like, you want to get it right, and it's important. And not getting it right is it can really affect people's lives. I mean, lots of people are in professions where that matters, but I think we are as well.
I think we have time for one more question. As AI tools become increasingly available and implemented into every sector of society, do you see AI as something to adapt to or to approach as inherently threatening in the context of digital privacy?
I think it's something that we're going to ultimately need to adapt to. I mean, it really depends on what it is. Oftentimes people are asking about AI, but what they're really talking about is large language models. And I just think it's important. Like, this something was taught to me by a Princeton professor named Arvind Narayan, and that, like, asking, do you like AI or not, is kind of like asking, do you like vehicles? Right. Right? Like, right? I think that large language models are something that really we need better tools to be able to use them anonymously and privately. I know some folks that EFF is working with who are trying to develop tools that will help you, the same way you can use in a similar way that you could use a Tor browser, or you could use other kind of VPNs to kind of obfuscate who you are when you're using the web. We need similar tools to be able to help people obfuscate who they are when they're using LLMs, because they have the risk of being so privacy invasive. And we need to invest in something other than 4 giant tech companies offering us these tools. Yeah. And there's lots of ways that we could do that, but we really do need to do it. And one of the things that we try to watch out for in the regulatory space is making sure that we're writing rules that allow a lot of different models and tools that can have different business models than the we just spy on you all the time one. And that could include like civic AI, that could be, the government of Switzerland has been developing a AI model that is developed only on Swiss materials, which I'm really curious to use at some point. But I think there's lots of different ways you can think about, or we could take the foundation models that exist and require them to be licensed in ways that, we made the railroad share the railroads with different things. There are different ways that you could think about making more options available to people. And I think the better, kind of thinking about it in that way rather than, how do we take the 4 or 5 models that exist now and make them better? I have a philosophy that is like, the answer to dictators is not to make them better dictators, it's to actually get rid of the dictators. But as a technology alone, I think artificial intelligence and neural networks are really fascinating and interesting. And I think that the benefits they could give to us are not small and are real. But if we just think that's magically going to happen, I think we're wrong. We had some benefits in the early days of the internet about how we thought about the future that they're not the same thinking, but we need a whole new set of people who can be like me and John Gilmore and Mitch Kapor and Barlow for AI and think about what are the markers we need to put down now, what are the fights we need to put down now in order to build a future that we want to live on. And look, part of that future could be deciding you don't want to participate in AI at all. I find it really annoying that it's being pushed on everybody. But I don't know that annoyance or the annoyance with some of the large personality billionaires who have built it should let us cloud ourselves from the things that we might be able to build out of a better world. Again, I'm just kind of a tech geek. I want my tools and I want my privacy too.
I love it. Cindy, I want to tell you the thing I loved the most about the book was how much you made the last 30 years of fighting sound like fun.
It was fun.
That's clear.
It's
That's really
totally
clear.
fun. And I, again, I'm trying to recruit people. Obviously,
yep.
It's not like we don't have dark times. I mean, 2 of the 3 fights are fights that we did not win and are still fighting today. I mean, Section 702, which is the way that Congress retroactively authorized the illegal mass spying program, is actually up to be renewed in Congress now. It was April 20th, and then they couldn't reach an agreement, and they kicked it out, Now it's up again in June, and it's because the Freedom Caucus is upset that they spied on Carter Page. But I'll take my friends where I can get them if we can scale this thing back. And they are pushing hard. There's a representative from Arizona who I don't think I agree with on anything but this, named Andy Biggs, who wants a Fourth Amendment warrant for the FBI to query the mass spying information. And that would be really great. And it's not a done deal. It's actually kind of a reach, but it's a lot closer than you might think if we push for it. So, but yeah, it is fun. There is a special fun to waking up every day and being part of the good guys. We have always taken it lightly. I had an intern in the early days tell me that what he liked about EFF is we were kind of like a merry band of freedom fighters. Yeah. And I'm of the school of the, if I can't dance, I don't want to be part of your revolution. And we've always tried to bring that to what we do. It's otherwise you can't do it for the long run, right? If it's drudgerous, if you can't find the joy, if you can't celebrate every little victory along the way, you're not going to do it for the long run. And geez, we need to.
It is a long run. Hear, hear. Our thanks to Cindy Cohn, Executive Director of the Electronic Frontier Foundation and the author of Privacy's Defender, My 30-Year Fight Against Digital Surveillance. Cindy will be available to sign books just after this program. For information about the Commonwealth Club World Affairs membership and upcoming programs, please visit commonwealthclub.org. I'm Adam Savage. Thank you for joining us.
Oh, thank you, Adam. Oh, my God. This was so fun.